All right. Hi, everybody. Welcome to Ivy Law Office's weekly Q&A. I'm Wilberforce Adjicum. I'm an attorney here at the firm. I practice immigration law. Attorney Jumoke, can you introduce yourself?
Hello, everyone. Happy New Year. This is Attorney Jumoke Oladapo from Ivy Law Office. I practice immigration law and estate planning. We do both practices area here at Ivy Law.
Mhm. All right. So today we're just going to talk briefly about estate planning, a checklist that you can use to keep track of your estate planning matters and documents. Okay. So Attorney Jumoke will go over a few things with you. And then obviously, if you have any questions, you can follow up with us at the end. We'll give you the contact information. So the first one we're going to discuss is last will and testament. Get us a bit of information about that, please.
Yes, so let me start with a little introduction before we get to last will and testament.
Do that.
So when we talk about estate planning, it's about planning ahead of time for who will do what on your behalf in the event of incapacity or death. It's not a very big word, and it's not a word for the wealthy, and it's if you know, so it's something that you want to look at if you have a family, if you're single, a young adult, an old person, at any stage in life, if you've acquired assets or you have beneficiaries. So this checklist is for everybody, I'll say, and I want you to get to it as soon as possible. So the most important thing that people know, or the most popular thing that people know when it comes to estate planning, is about last will and testament. And you find a lot of people saying, I need a will. I need a will. It's called last will and testament. So, what's this for? In your will, you'll be able to specify who you want to inherit certain assets and the properties after you die. This includes your physical assets like your real estate and your personal possessions, that's your personal property, both tangible and intangible. It includes your bank account, your investment account. Even your digital assets will be included. The recipients of your assets are called beneficiaries. So if you're the testator, probably you have beneficiaries that you want to give something to. So your beneficiaries can be your family members, your friends, nonprofit organizations, or anyone that is important to you. Okay. So in your will, you can name guardians. But now you're naming guardians for maybe your children, your minor children, or your pets. So you can plan ahead for your pets as well. And you choose who your personal representative or your executor is in your will so that they will carry out your instructions. So basically, you're leaving instructions for others to follow after you pass away. So by making a will, you ensure that the people and the causes you care about are looked after once you're gone. If you don't want to create a mess and you want to give some clarity and direction to your family and loved ones, then the minimum you want to have is to have a will in place. We can help you with that.
Mhm.
So let's look at the next checklist.
The next on the checklist is the revocable living trust.
Alrighty, for the revocable living trust, I'll say is a more sophisticated way of planning. And sometimes you want to go beyond having a will only. You want to look at what you have and see if you can be eligible to have a revocable living trust in place. So, a revocable living trust is a legal instrument that will let you distribute your assets after you die, just like a will. It's a substitute for a will. Okay. So, a revocable living trust is a legal entity or an agreement, and it will own your assets, the assets you put into it. It will still allow you to use the assets while you're alive, or the property while you're alive. And when you pass away, it's distributed to the loved ones you specify. If you have a revocable living trust in place, the important part, a benefit of it, is that it's an instrument that makes you avoid the necessity of going through the probate court. And there are a whole lot of benefits to that. So you want to speak with an attorney. In our office, we'll schedule you for a family wealth planning session and see if this is a good way for you to go with planning. So contact us if you want to know more about a revocable living trust. We do that a lot in our office.
Excellent. Next is beneficiary designations.
All right. So for beneficiary designations, this is when you name a beneficiary to get certain assets. And those assets are called non probate assets. So not all your assets go through probate. There are certain assets that skip probate and rather this transfer to the beneficiary directly after you die. The types of assets will include a 401k account, a pension, a life insurance. Okay. So if you name a beneficiary, for example, in your life insurance, that beneficiary gets the life insurance policy. It doesn't have to be inventoried for probate. But if you don't name a beneficiary in your life insurance, then it will have to go through the probate court. So those non probate assets are payable to beneficiaries and the designated beneficiaries, and that way you can avoid probate. That's it.
All right, thank you. Next, we have Advanced Healthcare Directive or Living Wills.
Alrighty. So having an estate plan is not just about planning for when you pass away or planning for death. It's also planning for life in the event of incapacity. Right. And when you talk about an healthcare directive and an advanced healthcare directive, it incorporates both the living will and the medical power of attorney. So it outlines, first of all, the medical power of attorney outlines who you want to be your healthcare agent in the event that you cannot make healthcare decisions by yourself at some point in life. So the healthcare agent will be able to make those decisions for you. But the legal document also incorporate what decisions you really want to be implemented. So you make those healthcare decisions for yourself ahead of time. And most of these decisions are sensitive that you don't want to put on other people's shoulders to make for you. So the living will is that piece of it. It gives medical preferences in case you're unable to communicate that. So, for example, I want to be on life support. I don't want to be on life support. If there's a vegetative stage situation, this is how I need to be treated. Those are the type of information a medical, a living will address. But the medical power of attorney are your healthcare agents that you're authorizing to carry out your instructions, your healthcare instructions. So you need to plan ahead with this advanced medical directive so that there will not be confusion, so that the doctors or the physicians will have clarity on who you nominate to make healthcare decisions for you and how you want to be treated in the event that you cannot make one by yourself.
Excellent. Next along that line is the financial power of attorney.
Alrighty, that's another popular estate planning document or instrument, and it's also for planning for life. All right. So a financial power of attorney will give someone the legal authority to manage your finances and properties for you. This tax includes things like paying your bill, making bank deposits, managing your real estate, and a whole wide range of powers. Okay. So you're choosing this person to act on your behalf in the event that you're not available or you have incapacity. And when you do this, you are essentially going to avoid the need of going through the guardianship court for a judge to nominate someone for you in the event you're of incapacity or if you cannot act by yourself.
All right. Excellent. All right. And what do we do with respect to insurance policies and financial information?
So, your insurance policies, your stocks and bonds are all part of your assets. And if you DIY, you forget
Mm,
those.
mm,
You forget to plan for those. So don't do it yourself. Because when you use an estate planning attorney, we're able to look at all of those assets, how they are titled, and how you want them to be passed on to loved ones, and if you have beneficiaries designated. So it's a very good idea for you to keep all your insurance policies documents together. All right, whether it's a life insurance or your health insurance or your car insurance or your home insurance, you should keep all those financial documents and instructions together in a place where they can be easily accessed by someone you will tell about them. So, your bank accounts, for example, your credit cards, your mortgage, your tax returns, your pension plans, retirement benefits, investment portfolios, all those are financial documents. In fact, we want you to keep an inventory of all those financial documents. Store them in maybe an Excel spreadsheet. Be financially organized so that your loved ones or whoever becomes your representative, whether as a power of attorney or as a personal representative, is able to know what you have and where you have it, number one. And also, none of your assets will be lost to the government. All right. So write in a notebook, and if possible, you can keep all those financial documents as part of your estate planning portfolio.
all right. Now, next, what does one do with their identity documents?
So, identity documents such as your ID, your social security card, your birth certificate, your marriage certificate, divorce certificate, prenuptial agreement, and so on and so on. You want them to be kept in a place where they can be easily accessible by your executor. Because you probably will need those either in the event of incapacity. You want someone trusted to know where to be able to access them.
Excellent. And what about titles and property deeds?
So for your titles and property deeds, you want to keep those maybe with your estate planning portfolio. Because, for example, if you have a trust, a revocable living trust, your deed, your trust deeds will be part of what will show that you've transferred your home into your trust. So make sure those documents are well kept and probably with your estate planning portfolio.
Right. Next, something most people don't think about digital account logins and passwords.
All right. So we are in a digital world, and everything right now, a lot of businesses, a lot of accounts, usernames and passwords. And for one, I can't even keep up with my usernames and passwords. It's just too numerous. Okay. So If you can't keep up with that, do you expect someone else to know it that you trust? No, they may not. They may not be able to access your account. So, an average person under 70 years old may have more than 160 digital account. So, to help you manage it, you want to consider using a password manager or a digital vault or something like LastPass, you know, to keep your digital information in. In our office, we also have a simple document called a digital asset checklist, where we make that part of your planning portfolio. So you want to put all this together, and you may also consider naming a digital executor. The person could still be the same person as your personal representative or your executor in your will. So this person will be the one probably managing your digital assets and distributing it to the right people that maybe you distribute those assets to.
All right. Cool. So you get your Facebook and Instagram and everything covered.
Exactly.
Yes. Now, next is funeral instructions and wishes.
All right. So part of estate planning is planning whether you want to be buried or cremated. And if you have special wishes that you want to be implemented at your passing, you need to write it down, because at that point, a lot of people are grieved and they may not be at the right frame of mind to properly plan for you. And they may not even know what your wishes are. So they'll be doing what they wish, not necessarily what you wish. So let your ones know whether you want to be buried or cremated. But more importantly, as part of your estate planning portfolio, you want to have final disposition instructions, which is part of what we provide for our clients, so that you outline your wishes and you outline your special wishes. You can even put the plot number, the burial cemetery, whether you want to be cremated, whether you want a particular song to be played, whether you want something to be donated to someone. You can design your own funeral, basically, if you want to. So, and the good thing is that if you have this properly documented, your loved ones will want to honor your wishes and follow it. So, have this in place and have it as part of your estate planning checklist.
Awesome. So you have all these documents. What do you do with your estate planning documents?
So once you have your estate planning documents, you want to store them in a safe and accessible place. Consider telling your loved ones where this document are, and give a copy of the documents to the people that need them. For example, your healthcare directive, you should give a copy to your primary physician, your healthcare doctor, to keep on your healthcare record. The power of attorney, you want to give a copy to your power of attorney, the agent, the primary agent you choose. Your will, you want it to be stored in a safe place in your home or in a safe deposit box or with the county, and let someone know where you keep in those legal documents. The same thing with the revocable living trust. You don't have to record or keep the revocable living court with the living trust with the court, because it's not a court document, but keep it in a safe place that a trusted person that you choose will know how and where to look at them. So, again, one other thing I want you to know is that an estate, having this estate planning document is not a once in a lifetime assignment. And this is why. Your life is constantly evolving and changing. So, for example, you may be young and in your early 30s or 20s and not married. Then you get married and have children. Then your children start going to college. Then your children are now grown up, and now you're retired. You have assets, you sell assets, you increase assets, you remove assets, or even the beneficiaries you choose, you may fall out of love with them, or some of them may pass away. So life happens at different stages. So you need to be reviewing your estate plans from time to time to meet your current need. So an important piece of estate planning is also reviewing your estate plans from time to time. We recommend 3 years in our law office. At least review your estate plans 3 to 5 years. And if there are changes to be made, you can reach out to your estate planning attorney to update or make those changes. Why? Because we want your plan to work when it's needed. So that's it about what you do with the documents or what you do after setting up a plan. So that's a vital part of our estate planning process in our office. We review your estate planning portfolio for you regularly.
All right. So that's it for us for a little bit talk on the checklist for estate planning in Maryland. Thank you, Attorney Jumoke Oladapo. How do people get a hold of you to get some of this work done for them?
So this year, we want to increase our subscribers on YouTube. We want you to follow us, like us, share. If you like what you're hearing, share it with your friends. Let other people come and learn. And more importantly, we want you to engage the services when needed. So, how do you connect with us? You can call our office 301 276 0887. 301 276 0887. We have a website, www.ivlawoffice.com. We're on Facebook, we're on YouTube, we're on Instagram, we're on LinkedIn. But the best way to connect with us is to give us a call or email us. We'll look forward to serving you better this year. And we'll look forward to just being your trusted advisor. So have a great year.
Thank you very much for joining us. Have a good day, the rest of your week. See you next week.
See you next week. Thank you.
Mhm.